Yes, Mr. Strang.
Yes, my lord. I was about to start on section 18.1 itself.
Yes.
And the offences, well, that's, by the way, that's at page 386, just so we can get back there. The offence being the failure to take the steps required by the enforcement notice by the deadline imposed by the notice. And I say that section provides for a continuing offence, or the possibility of one, depending on the facts, in the sense that the offence of failing to take the steps required continues so long as the steps aren't taken. And I say that's most clearly indicated by the terms of section 18.1 itself, which impose a criminal liability for every day after the first day, during which the requirements of the enforcement notice remain unfulfilled. And sections imposing criminal liability accumulating day by day have been treated as providing for continuing offences in other authorities. For example, the case of Hodgetts, which begins at page 1077. And now this was concerned with offences under section 18.9 of the 1971 Act in England and Wales. And those offences are set out at page 1084. In particular, we're looking at section 89.1 at B, at B of page 127, and section 89.4 at C. And Lord Roskill analysed the first one, section 89.1, as creating a once-and-for-all offence, and section 89.4 as creating a continuing offence. And that's set out over the page at 1085 at A through to C. Your Lordships will have seen this passage cited elsewhere, so I won't read it all, but the initial offence created by subsection 1 is complete once and for all when the period for compliance with the notice expires, but it is plainly contemplated that the further offence of non-compliance created by subsection 4, though it too is a single offence, may take place over a period of time, since the penalty for it is made dependent on the number of days on which it takes place. So a daily penalty is a clear indication of a continuing offence. I should say, by the way, if we just go back to section 89.4, there is a specific event mentioned there, the first conviction. But one does not need to include the date of first conviction in a complaint about section 89.4, it being a continuing offence. So I compare that to my learned friend's submissions about the specific event in section 18.1, the specific first day which is expressly referred to. So too in section 89.4, a specific event is expressly referred to. But that doesn't provide a reason to treat it as a once and for all offence. The same approach to daily penalty was taken by Mr. Justice Wolfe, as he then was, in the case of Tandridge. That's one that your Lordships have separately. It was sent in by email. I'll just get my copy of it. Sorry. The citation is 1983 45 Property and Conveyancing Reports, page 408. And this also concerns a decision on Section 89.4, the same section, and whether it was a continuing offence. In this case, the court needed to decide that question because the defendant had been earlier acquitted of the offence. So the question whether that defendant could be charged again depended on whether the offence was a continuing offence. And I pick it up at page 412 in the report. Where Mr. Justice Wolfe, in the third paragraph, identifies the question, is this a continuing offence? And then the main paragraph on that page sets out his reasoning as to why it is a continuing offence. Whether or not subsection 4 creates a continuing offence is largely one of an impression from the language of subsection 4 itself, bearing in mind that it specifically provides that there is to be a fine for each day following the conviction. It's my view that the impression created by the language of subsection 4 is that it creates a continuing offence. And then Mr. Justice Wolfe goes on to find support for that impression in the context of the Act. And I'd ask your Lordships to read the rest of that paragraph because it is relevant to the discussions that your Lordships were having this morning about the practicality of further enforcement notices and whether Parliament would have thought that was a satisfactory way to enforce planning law. So apart from the imposition of a daily penalty, the other reason I say Section 18.1 is a continuing offence is because the obligation to comply with an enforcement notice must be read as being a continuing obligation. The enforcement notice specifies a forbidden state of affairs and requires the landowner to take specified steps to put things right. And that's the primary obligation, to put an end to the forbidden state of affairs. Of course, the notice specifies the time by which that person has to take the steps required, but it doesn't follow that they're no longer required to take those steps after that date. I say that would be a most unsatisfactory and unlikely result. It would mean that if a person failed to comply with an enforcement notice, the minister would then have to serve a fresh notice in order to impose an obligation to put things right. So the obligation continues. And I say what one can glean from the authorities is that a continuing obligation gives rise to a continuing offence. I accept that in each case the language of the statute is critical as to whether there is, as to the kind of obligation that's imposed. But the point I make is that when the courts find the obligation is ongoing, they also find that a failure to comply with that ongoing obligation is a continuing offence.
So are you going to tell us at some point how you say we should read the final lines of Section 18.1?
Yes, I will, my Lord. But for the time being, if I may, I'm just going to look at how continuing obligation gives rise to continuing offence, because that's a theme, I say, in the authorities. And my first example is the case of Rusnak Johnson. That's page 593. And the question for the court here was whether the prosecution was time-barred and whether the offences were once and for all or continuing offences. And the Divisional Court conducted a survey of the authorities from page 609, paragraph 68, through to 611, paragraph 79, and then went on to consider the provisions under section 171D of the English Act. And I accept those provisions are different from the provisions in section 18.1 of the Trinidadian Act. I accept that they say, for example, that somebody is guilty of an offence if at any time after a specified period for compliance. But I do make the point that at any time is the first time those words are used in a planning offence in England, but it's not the first time a planning offence was found by the courts to create a continuing offence. So at any time is far from decisive. But the point I take from Rusnak-Johnson is that once the court decided that the relevant provisions imposed a continuing obligation, it followed in the court's view that the offence was a continuing offence. I take that from paragraph 82 at page 612. In fact, I can take it also from paragraph 80 at the very bottom of 611. There's an ongoing obligation to comply with the planning contravention notice, as in BT. The offences of a continuing nature until the requirements of the notice are met. And then at the end of paragraph 82, which is section E on the page, the obligation to comply with the requirements of a planning contravention notice is of an ongoing nature, and likewise the offence of failing to comply with those requirements is a continuing rather than a once and for all offence. And the Divisional Court refers there to the BT case, and the same reasoning, you'll see the same reasoning and the same question asked by Lord Bingham in the BT case, which is at 993. And I'll take it up, if I may, at page 1001, because this is where Lord Bingham asks himself the critical question in my submission. In the second paragraph, does the duty to reinstate in accordance with the specification continue indefinitely so that his failure to reinstate it in accordance with the specification constitutes a continuing offence? That's the critical question that Lord Bingham asks himself in BT. And then, as you'll see when he goes on to decide that this is a continuing offence, it's by continuing reference to, repeated reference to, the fact of a continuing duty. So you'll see at the start of paragraph 4, it's difficult to give any effect to section 95.2 if there's not, in fact, a continuing duty. And he finishes his paragraph there by saying that section 95.2 points strongly towards the continuation of the duty. And then he checks that against other provisions in the next paragraph, not inconsistent with a continuing duty. And the question he's asking himself, is this a continuing duty? If yes, continuing offence.
Yeah. It's rather reminiscent of the opening of Lord Rogers' judgment in Soneggi, if you remember, that the daughter who's told she's to be home by 11 is under a continuing duty to come home even after 11 has passed, whereas the conjurer who you've ordered for your children's party to come on Saturday is not under a continuing duty to turn up after Saturday has passed without his appearing.
Yes.
I mean, it depends what
Well,
construction you put on the
yes.
what the nature of it, what construction you put on the
What I've said, yes, well, from what I've said so far about the structure of the Act, I would say the answer is very clear that we're in the case of the daughter rather than the conjurer in this case, because the obligation is to put an end to a forbidden state of affairs. That's an offending building that should not be there, for which there's no permission, and which one has been ordered to remove.
And Section 19 is a continuing obligation. Yes. Imposes a continuing obligation anyway.
Yes. Yes, my lord. So that was BT. Yes, and once we have a continuing duty, if the duty to comply with the enforcement notice is ongoing after the expiry of the period, then so long as that duty remains unperformed, the offence is being committed on every day. And the result of that, for the purposes of the time limit, is that if a complaint is made within 6 months of any such day when the offence is being committed, then it's made in time. And that's the effect of the authorities I've cited. I'll take your lordships to two, because they both concern a case where there was a specified period for compliance, just as in this case. And the first of those is the Camden case, that 1013. And a summary of the issue is probably best taken up at the top of page 1016. That's section A. Because the specified period expired on the 25th of December 1993, the information wasn't laid until the 19th of June, and the information alleged that there was non-compliance on 6th of March 1995. The penal section you can see at the bottom of page 1016. Again, I accept the wording is different. The wording expressly confirms that the obligation to comply is ongoing. But this isn't the first case where an ongoing obligation is found. Ongoing obligations have been found in respect of many offences where it doesn't so specify, as in section 376(2) here. But the divisional court's reasoning is over the page at 1017. So Lord Justice Henry breaks the obligations down to three. There is an obligation to do the works on time, but there's also a substantial obligation to do the works, which continues. And now of course, he's told expressly that it continues in this case. But the decision, that in mind, with a continuing obligation, the decision is at D. Although the obligation to complete was irreparably breached by Boxing Day of that year, the obligation to execute the works continued, notwithstanding the expiry of those periods. In those circumstances, as the work had not been done by the 6th of March 1995, the defendant was in breach on that day of the continuous obligation. And so the information was brought in time. But while we're here, I'll just show your lordships the form of the information that Lord Justice Henry would have used in that case. It's there at section E. This is relevant to the question whether the expiry of the period is a material averment. In this case, it's plain the Divisional Court found it wasn't, because the model information that Lord Justice Henry would have used identifies the notice, identifies it by the date of its service, and avers that there was a failure to comply as at the 6th of March 1995. It does not aver the date upon which the specified period expired. The second case I'll take your lordships to concerning the expiry of a specified period is the Penton Park Homes case, and that's at page 1092. And this concerned a failure to carry out works required by a condition of a license within a specified 12-month period. And that 12-month period expired on the 9th of January 1968. The information alleged a failure to comply as at October the 11th, 1972. And the reasoning of the Divisional Court is at page 1095. So I'll pick it up in the third paragraph to say that an offence which consists in a positive action performed on a particular day is a once and for all offence is one thing. To say the same about a failure to perform an act which an offender is required by law to perform is quite another. That's the case we're in here, failure to do something required by law. In my judgment, it's impossible to resist the conclusion that Parliament intended the offence of failing to comply with a condition of the kind expressly contemplated by Section 5.4 of this statute, that's to say a condition requiring the work to be completed within a specified period, to be a continuing offence. And he goes on, as a matter of language, the failure continues. And this was, yes, Mr. Justice Bridge. He goes on to say, if one were forced by the language of the Act to the contrary conclusion, it would be a very startling conclusion, which would show, as it seems to me, that the machinery for the enforcement of a condition of this kind was conspicuously defective. And that was in circumstances where there was a power in the local authority to do the works. You'll see that from the bottom of page 1094, the previous page. That was a submission made by the defendant and rejected by the Divisional Court, that after the 6 months had expired, the local authority's remedy was to do the works itself. And one reason I would say why that machinery would be defective is that if there was only going to be one chance at prosecution and conviction, that would allow the landowner to make a calculation, to flout the law and pay a one-off fine, and wait to see if the hard-pressed ministry can make arrangements itself to carry out the works. So those are the two authorities I would take your lordships to concerning the effect of a continuing offence on a time limit, even where the period has been specified. And applying the same principles to this case, the complaint was made in time. It was made within 6 months of a day when the appellant's offence was being committed. The complaint is at page 4, your lordships have seen it. It alleged an offence committed as at 4th of August 2008, and the complaint was made on the 9th of October 2008 in time. I'm just going to deal with the appellant's specific point about the extra words in section 33(2), which the time limit says the complaint should be made within 6 months from the time when the matter of complaint arose, and not after. And those 3 words are said to, as I understand it, have the effect that in Trinidad, the Supreme Court's Act doesn't allow for continuing offences. Because there's always a first date of offence, and the words "and not after" are supposed to, as I understand the submission, limit the complaint to be brought within 6 months of the first time the matter of complaint arose, rather than any later time. So the argument is that in Trinidad and Tobago, because of those 3 words, a continuing offence doesn't have the same effect on time limits as elsewhere. And I say that's wrong. That's the point to which I address by referring to the authorities of Singer Sewing Machine Company and Skinner and Mary Ewan. Let's take a look at Skinner, which is page 1087. Except what my learned friend says, this concerns a different kind of offence in a different kind of circumstance. But the point about the effect of section 33(2) of the Summary Courts Act was expressly considered. At page 1088. The second paragraph tells us that the first submission was that the complaint had been filed out of time. And the basis of that submission was, third paragraph, the terms of section 33(2) of the Summary Courts Act, or the ordinance as it was then called. And that submission was answered by the fact that the offence was a continuing offence. That's the penultimate paragraph on the page. The Court of Appeal accepts that submission. I'm not suggesting that the offence in Skinner or in Shaw and the Singer Sewing Machine Company is comparable to this offence. What I'm saying is that the courts in Trinidad and Tobago have never considered that the words "and not after" in section 33(2) of the Summary Courts Act restrict the effect of continuing offences on the time limit in that provision. And the same point can be taken from the Shaw and Singer Sewing Machine Company. And perhaps the easiest thing to do is just refer your lordships to the headnote at page 1117. There are actually 3, as far as I could find, 3 reported authorities on continuing offences and section 33(2) of the Summary Courts Act. The third one is British West Indian Airways and Farmer. Your lordships can see a reference to that if you wish at page 144 of the bundle, because it's referred to in the respondent submissions below at paragraph 64. So just for your lordships' notes, page 144 to 145 of the electronic bundle. And in none of the cases in Trinidad, none of the reported cases in Trinidad has it ever been suggested that the words "and not after" mean that a continuing offence doesn't have the same effect on time limits as elsewhere. And that's the reason I also refer to the Australian High Court case of Cook and Cook. Again, that this is a different kind of offence, and there was a debate in the judgments over even whether it was an offence and whether the statutory time limit applied. But the point is that if it did apply, the fact that the offence was a continuing offence would allow a complaint to be brought more than 12 months after the first commission of the offence. And that was the conclusion of the High Court, notwithstanding the fact that in that case, as in the Trinidad time limit, the time limit ends with the words, "and not afterwards." You can see that, my lords, at page 1131. So that's the point of those three authorities, to deal with the "and not after" qualification. I do accept that the time limit has an effect, and that's the Chertsey Justices and Franks case. I don't think I need to cover that anymore with your lordships. Just to deal, though, with the point that in Franks, the divisional court quashed the conviction. Now, that's at page 1116. No, 1115, sorry. Perhaps I should start at page 1113, because if we take a look at the middle of the page, Mr. Frank contends, you'll see that as at the date of conviction and sentence in this case, Section 16 of the Administration of Justice Act 1960 had not come into force, so the court had no power to rectify the error by amendment. And so, having found that the complaint included dates that were not properly before the magistrates, the court decided, having no power to alter the fine, at the bottom of page 115, in the absence of any power to alter the fine, this court must, with some reluctance, quash the conviction. Now, in Trinidad and Tobago, under the Summary Courts Act, there is, of course, a power on appeal to alter the fine and to correct mistakes. And that's at section 149, page 482. So, Section 149 of the Summary Courts Act, subsection 2, the Court of Appeal may affirm, modify, amend, or reverse the decision, either in whole or in part, and if the court thinks a different sentence should have been passed, quash the sentence and pass such other sentence warranted in law. So the fact that the complaint included, of course, there's also a power to amend the complaint. Although I understand it to be conceded there was no defect in the complaint, but the power to amend the complaint is at section 145. Power to amend the complaint on appeal, that is. Section 145 on the previous page.
It would be helpful at some point for us to be addressed on what we should do if
Yes.
on any view, if
Yes.
we uphold the conviction to some extent,
Yes.
there's clearly going to have to be some modification of it.
Yes.
And a modification of the sentence also.
Yes.
And whether those are matters we can deal with ourselves, or whether we should be remitting to the Court of Appeal.
Well, I say your lordships can. Your lordships, if the Court of Appeal has these powers, I say so do your lordships.
So at the moment there's a conviction in relation to a period which means it's out of time, essentially.
The magistrate should have been concerned only with the period from the 9th of April 2008 onwards.
Yeah.
She sentenced in respect of a period that began earlier. That sentence can be adjusted to start at 9th of April 2008. That's my submission.
Can the conviction be amended?
Yes, because it's a conviction in respect of...
And is it necessary to amend the conviction, or is it simply a matter of sentence?
It's simply a matter of sentencing, my lord. There's one offence...
If you're wrong on that, can the conviction be amended?
It's a conviction for one offence. It's the same conviction whether the magistrate addresses herself to period before 9th of April 2008 or only the period after it.
Well, the
I
sentence
think it
depends on
follows
the
from the...
conviction.
Yes, the sentence follows from how many days the magistrate's considering, but it's one offence, a failure to take the steps.
It follows from your concession that they should never have been convicted of the offence in respect of the earlier period.
But they're convicted in respect of a single offence, my lord. The period goes to sentencing.
Is that right?
Yes, it is. Yes, it's my submission. I don't understand why it's wrong. Perhaps that's my...
The effect of Section 33(2), it seems, is that they should never have been prosecuted in respect of the default in the earlier period.
Well, they're prosecuted in respect of... They're prosecuted for failing to take the steps required. The period expressed is a period that began on 16th of January 2006. It should have begun on the 9th of April 2008. The complaint can be amended either by the magistrate or the Court of Appeal to state the correct period of offending.
It hasn't been.
No, it hasn't been, but there's always the power to do so, and there's a power on appeal to do so.
Yeah, but you didn't seek the Court of Appeal
No.
power to amend it in an appropriate way, did you?
No, indeed not. But that, in my submission, that does not go to the safety of the conviction. It's simply a matter of sentencing.
Indeed, presumably there's a power to, if you acquit somebody of murder, you can convict them of manslaughter.
Well, Section 149(2), in terms of, as far as the Court of Appeal is concerned, the Court of Appeal can affirm, modify, amend or reverse the decision, either in whole or part, pass such other sentence as warranted in law.
Your point is that there was an offence.
Yes, exactly. There was an offence, a single offence, and I will, when we go on to look at the materiality of dates in continuing offences, the authorities suggest that dates are not a material averment in continuing offences. Errors as to the start or deadlines imposed upon the end, as my Lord Reid asked at the beginning, are not material to the question whether the court is properly seized of the offence.
Well, I think it's conceded that the complaint referred to a continuing offence insofar as it referred to a period of time. Yes. But it's also, I think, submitted that the end of that period was just incorrect. It should have been the 9th of October 2008 as opposed to the 4th of August 2008. And, what do you say about that?
Well, perhaps I'll take your lordships to the Camiab case. But before I do, there's one point I wanted to take from Penton about the start date. That's.
I would have thought. My experience isn't of prosecutions of this kind, but if you were, just say, for example, the charge was one of sexual abuse of a child between specified dates, if you made any attempt to lead evidence there had been abuse outside those dates, it would be objected to as inadmissible.
Yes, my lord, that's a different kind of continuing offence in my... That's an offence that's committed intermittently over a number of days on different occasions. Mm. So there's an act of abuse on one day, there's an act of abuse on another day, there's an act of abuse on another day. It's a different kind of continuing offence from one which is simply a failure to do what the law requires you to do, which you're failing the whole time, but you're only committing one offence.
And on that occasion, you would be charging separate incidents.
Yes.
You wouldn't necessarily be able to identify the exact date, so you would give a range of dates for those incidents to take place. but they would be separate offences, and you'd have to make sure that they were identified as separate offences.
But you couldn't lead evidence of a planning officer coming along to the site outside the period specified in the charge in order to establish that the offence had been committed.
Well, in my submission, my lord, you don't need to. You just need to show that the building was still there on a date specified in the notice, and indeed, as far as sentencing is concerned, show the date up to which the building was still there.
In a sense, on your submission, it's only the last date that's relevant.
Yes.
Because it's every day from the date of enforcement, subject to the 6-month limit, up to the final date where they're still failing to comply.
Yes, my lord. The state of affairs is still the forbidden state of affairs.
And to take your example, or the example of sexual offences against children, if the complaint was that it was between particular dates and it subsequently transpired that there was no prejudice caused to anybody and the date was wrong, you could amend the complaint.
Indeed, yes. The touchstone for amendment is whether the defendant's been misled or prejudiced.
Yeah. The alternative is that somebody who potentially has committed a criminal offence goes free.
Indeed. And those principles are made express in the Summary Courts Act. The errors in the complaint are only material if the defendant's been misled or deceived. But going specifically to a question about the start date in an information, there is a useful decision in the Penton Park Homes on that very question, which is at page 1095. Your Lordships will recall that the period specified in the notice expired on the 9th of January 1968. At the bottom of 1095, there's an objection to conviction because the complaint misrecited the date on which the misrecited the date upon which the time to comply expired. And that's the last two paragraphs of page 1095. So picking it up at the end of the penultimate paragraph, the summons alleging a failure to comply added gratuitously the words, "The period for the completion of the work having been extended by the Council until October the 10th, 1972. And that was simply wrong. There had been no such extension, as the court goes on to explain in the next paragraph. Mr. Justice Bridge answered that objection over the page, at the top of page 585. The objection founded on this misrecital, which Mr. Sullivan urged on us today, seems to me, however, to misfire completely. For once it's decided that this was a continuing offence, it seems to me to follow that the misrecital, alleging an extension of time for compliance with Condition 28, was, albeit inaccurate, of no materiality. What the court's concerned with in a continuing offence is the state of affairs at the time the complaint is made, or at the time alleged in the complaint, I should say, and not exactly when the specified period expired. We'll see that also from the Ceredigion case. Perhaps this is the right time to deal with the appellant's point about the reference to the first day of non-compliance in Section 18.1. As I understand it, because the appellants say because Section 18.1 refers expressly to the first day during which the requirements are not fulfilled, the first day has to be a material averment without which there can be no continuing offence and no complaint. So acquitting in respect of the first day or amending to exclude the first day is impermissible, or it renders the conviction unsafe. In my submission, there's no reason in the wording of Section 18.1 or elsewhere in the Act to say why Section 18.1 should be approached differently from any other continuing offence. The words in Section 18.1, let's just go to them, effectively impose a fine of a maximum of $1,500 for the first day during which the requirements of the notice remain unfulfilled, and a fine of a maximum $300 for every day after the first day. And I say all that means is, in the case of a continuing offence, there's a different maximum fine for the first day compared to every other day of the offence.
What do you say is meant by the words, the first day during which the requirements of the enforcement notice remain unfulfilled? Is that the day after the expiry of the notice, or is it the first day specified in the charge?
Well, I would be inclined to accept the more natural reading is it's the first day after the expiry of the notice, but I say that doesn't make any difference to my reading, which is that the offence, Section 81, simply imposes a different maximum fine for the first day of offence or the first moment of offence, which is also apt for cases where it is a one-off offence, and it imposes a different maximum fine for every day thereafter.
So on your reading, a fine of $1,500 could not have been imposed for day one here because day one couldn't properly fall within the ambit of the charge.
Yes, that's my reading. I agree with Your Lordship that you could read it as saying that the first day covered by the complaint during which the requirements of the notice remain unfulfilled. But I accept that that's a slightly less natural reading, and as I say, it does not affect my submission that all this is doing is telling you what the maximum fine is for the respective days. So there's a different maximum fine for the first day of the offence compared to every other day of the offence.
Okay.
As my Lord Reed said at the outset of the day, it's a marker for sentencing. And I say from that, it doesn't follow that, unlike all other continuing offences, in this one you have to include the first day of the offence in any complaint. Of course, it's correct there's no offence.
Although obviously the period in the charge begins on a given date, that date is not the first day during which the requirements remain unfulfilled within the meaning of Section 18.1 and therefore doesn't attract a $1,500 maximum.
Yes, that's what I say, my Lord, yes.
It just gets a maximum of $300.
Yes, I say so be it.
Same way as every other day.
So the proposition that sentencing provision means that one has to include the first day after expiry in order to bring a proper charge doesn't follow. And I say it's contrary to the authorities on continuing offences, which your lordships have looked at briefly, starting with, well, I would start with Ceredigion, but let's go to Maltege first, just because I have to distinguish that, and I say it's readily distinguished. Maltege is at page 1019. And in Ceredigion, the court distinguished Maltege because Maltege is concerned with a one-off or once-and-for-all offence. Ceredigion was concerned with a continuing offence. And we can see that from page 1021. Of course, this is a case where not only did the complaint not allege the date on which the notice expired, the magistrates didn't even receive any evidence as to the date of expiry of the notice. But as far as the reasoning of the court in Maltege is concerned, let's pick it up at the bottom of page 1021, the penultimate paragraph. And we're concerned, well, I think you've seen this. We're concerned with section 179(1) of the 1990 Act. I've forgotten the date of the Act in this case, but yes, the 1990 Act, which was the successor of section 89(1) of the Town and Country Planning Act 1971, which we've seen in Hodgetts. So we saw in Hodgetts that this offence is a one-off offence. Section 89(1) of the 71 Act and section 179(1) of the 1990 Act, both one-off offences. And that's confirmed by Mr. Justice Laws in the penultimate paragraph, and he follows the analysis of Lord Roskill. And he makes it express. The House of Lords made it clear that these offences were, as it were, single offences. And that means, single offences there means one-off offences, once and for all offence. And the reasoning as to the importance of the date is at the bottom of the page, in the last paragraph. It's part of the very definition of the offence. The compliance, it's inherent implicitly in the terms that the compliance period must be alleged and proved so that the court can see whether the facts alleged to constitute a breach have occurred. This is the bit that I would emphasise. Have occurred at the time and the only time with which the statute is concerned. And that's what distinguishes it from a continuing offence. At the time and the only time. It's a one-off offence, and there's only one time with which the court is concerned.
And the offences were, first of all, the hire and storage of plant, and secondly, the breach of planning control.
This is concerned with the breach of the enforcement notice here.
Yes.
Yes. And that qualification of Mr. Justice Laws is picked up and emphasised by the Divisional Court in Ceredigion when they distinguish Maltege. So Ceredigion is at page 614. So, if I go through to the reasoning of the Divisional Court, see page 623. The court's reasoning on the provision in Maltege is at paragraph 27. Your Lordships will see that here. That qualification is emphasised at the bottom of that paragraph at G. court's concerned with the time and the only time. Well, rather, the court needs to have a pleading and proof as to the time and the only time with which the statute is concerned. That's distinguished under the provisions that were under consideration in Ceredigion, as you'll see going on to the next paragraph, because this offence is a continuing one. After the period for compliance has expired, the offence is in that sense a continuing one.
This is talking about the non-materiality of the date when
Yes.
the period for compliance expired.
Yes. Yes.
Yeah, one can understand that. But what I'm finding startling, although it may be because I'm used to a different system of criminal procedure, I'm finding startling the idea that you can be convicted and sentenced for an offence which is wider in scope than the offence set out in the complaint. You said you were going to...
Well, I've narrowed it, but the complaint can only go up to the last date of the latest date you can mention in a complaint would be the date you file the complaint.
Yeah.
But that doesn't prevent the court from looking at evidence at the time.
Well, so you're telling me, I'm about to say that's news to me. If that's English law, then so be it. But is there authority for that?
Yes, we'll get to that. It's the Barnett and Kamiab case. Well, there's a general proposition that generally dates are not material averments in complaints. The point is whether the defendant was deceived or misled. And the point about charging an offence over a period of time is you're informing the defendant, as my Lord Stevens said, that this is a continuing offence.
Well,
the implication of that is you...
telling him that you're going to charge him with non-compliance between whatever it is, the 9th of April and the 9th of October 2008, if you're planning to lead evidence about events in 2017 or 2015. So.
Well, the implication of that objection is that a person can only be sentenced in respect of the 6-month period prior to the complaint, no matter whether they continue the offence after the making of the complaint.
But I thought you were telling me that he can be sentenced for the entirety of the period from the filing of a complaint up until the date of a trial, indeed date of sentencing, I suppose.
Up until the last date on which there's evidence that the offence was committed. That's correct, my Lord, yes. Now, I'm going to move on to... I'll show you that authority, but before we get there, I'll just show you... The reasoning in Ceredigion about the expiry of the time is page 624 at B. What matters and what the prosecution must prove is that the period for compliance has expired, so the defendant was under obligation not to contravene the notice. The exact moment at which it expired is no longer of critical or defining importance. So let's move on to Barnett and Kamiab then, to deal with both points, but specifically the point raised by my Lord Reed. Page 578. Now, this was a case concerning a confiscation order, and the issue before the court was whether, because the information charged one day of offence only, whether a confiscation order could only be made in respect of one day.
Now, this is an application for leave to appeal, and leave was granted on the basis that the appeal was arguable.
Yes, and they go on to dispose of the appeal.
Oh, I see.
Oh, I see. Yes.
Right. Thank you.
And the reason why this issue arose is because there was a previous case of Panay where an information had charged a summons had charged 1 day of offence, and the court had found that it could only make a confiscation order in respect of that 1 day of offending. But that case was distinguished here.
So that's paragraph 12, referring back to Panay.
The Panay decision, yes, paragraph 12. I'll pick it up at paragraph 31. This makes good. I do so because this makes good the point that my Lord Stevens was discussing earlier, that
31.
as long as the appellant knows the case he has to meet, if there are technical deficiencies in the drafting of the summons, they're not fatal. But in terms of addressing the question about whether an information such as that in Panay, which charged 1 day of offence, would lead to a confiscation order only in respect of 1 day, the court went on to consider what's the meaning of a continuing offence, and what are the requirements for a valid information in respect of a continuing offence. That was the reasoning. Those are the issues the court was concerned with here in Camiab. So we pick it up at paragraph 36. I won't read 36 and 37. 38 at the bottom of the page, then reference to the Ceredigian case, which is where they say the court considered the formal requirements for a valid summons in a continuing offence. I do emphasise the last line on that page. Generally, in indictments or summonses in criminal cases, dates are treated as not being material averments. And then they endorse the reasoning of the court in Ceredigian in respect of continuing offences. And then they go on to consider what was the effect in that context of charging a person in respect of a single day. And that's over the page at paragraph 41 and 42. So, familiar ground at the beginning of paragraph 42, whether an offence is by its nature a continuing offence is a matter of construction. And then here's what they say about charging a single day. We would suggest it would require very clear words in the summons and in the presentation of the case to limit it to a particular day. No rational prosecutor would wish to proceed in that way without some wholly exceptional circumstance, and no rational defendant would understand the charges being limited to 1 day unless the prosecutor specifically said this was position. And here's what I say is a statement of principle which applies generally. Once the offence is a continuing offence, starting at the expiry of the date for compliance and ending, if at all, at some point thereafter, the end date is not, we would suggest, a material averment in the determination of guilt. If it is disputed, which it was not in this case, it will be a matter for the trial court to determine if it's relevant to sentence. Absent some special circumstance, the court is not constrained in that exercise by dates in a summons or an indictment. That's what I say about the effect of the last date in the complaint being 4th of August 2008. was probably the last day that Mr. Cedeno had been there to check that the building was still in place. But the respondent was entitled to present evidence before the magistrate that the building was still in place on a later date. And the magistrate was entitled to sentence in respect of that later date.
Unless it caused prejudice of some kind. If, for example, there was a suggestion that at a later date it had been remedied.
If there was a suggestion, my lord...
At a later date it had been remedied.
Yes. Well,
if there's no suggestion of prejudice, then your submission is it doesn't matter.
and indeed, if there's no dispute that the building's still in place and still offending, I've already shown your lordships the cases of Camden and Penton Park. I accept that those were not cases where there was a sentence that accumulated by day, but both those cases also confirm the point that the... no, those were expiry dates, yes, sorry, I don't need to discuss those. Perhaps, unless I can assist you further on that particular point, I'll just go on to the Court of Appeal's judgment. My Lord Reed asked me how the court would adjust what the Court of Appeal said, and as I'm differing from the Court of Appeal's reasoning in some points, perhaps I should just quickly go through what they have said. So, Court of Appeal's reasoning on these questions.
Is this authority referred to in Blackstone? Because I can't find it.
Is Canada referred to Blackstone?
No, the one starting at page 578.
578. Yes, the Barnett and Camion.
I can't find it.
Well, it's April 21. Court of Appeal, April 21. I haven't looked in Blackstone. As far as I could see in Westlaw, there's no doubt over the authority. It's not been doubted since.
Certainly, if evidence is led, say for instance bad character evidence or whatever, that shows a defendant in a very bad light and actually having committed other offences apart from the ones charged, you can't take those into account in the sentencing exercise. But here you say it's a continuing offence. Yes. The end date is immaterial. It just goes on until...
Yes. Yes, and that's in the nature of the offence. Nobody's taken by surprise by that.
So why does Lord Roskell say that these offences should be charged as having been committed between two specified dates?
My Lord Stevens' answer was that it makes it plain that it's a continuing offence.
Because in reality, what the person's in jeopardy of is not conviction of committing the offence between two specified dates, but committing the offence between the earlier date and the latest date for which evidence is led at the trial.
Yes, my Lord, and that's the nature of the provision.
And
Section 18.1.
The limits of the evidence.
Section 18.1 imposes the criminal liability for every day during which the requirements of the notice remain unfulfilled.
Yeah, and so the procedure proceeds on the basis that the scope of the evidence isn't, and indeed the conviction and sentence aren't fixed by the scope of a charge.
No.
May I ask this? If in the case of a continuing offence, there were a conviction and a fine imposed for the particular period, and then a further charge was laid in respect of a later period, how would the sentencing for that work? Because if the later picture isn't before the judge at the earlier time, is it possible the judge might impose an unduly severe sentence for the
if the judge on the second charge had not been informed that there's a previous charge.
No. If the judge dealing with the first charge was not cognizant of a potential charge for a later period, is it possible that too severe a fine might be imposed at the first stage in relation to that particular period?
When that situation is likely to arise, if there's an outstanding charge in respect of the one offence, and the prosecution is entitled to lead evidence that the development's still there, the week before the trial of that charge, there would be no reason to bring a second charge.
Of course.
The second charge will happen after conviction and sentence in respect of the first period. And so the second charge will only be concerned with the period after that sentence. But the first charge is most unlikely to be sentencing. On the first charge, I don't see a circumstance where the magistrate will be sentencing somebody in respect of a period covered by a second charge, because there would be no reason to make the second complaint.
Indeed. And so what will be the impact on the magistrate's approach to the sentencing?
There's no impact in my submission. The magistrate has a charge before her. She's given evidence as to whether the offence ceased, and if so, when. Or she's given evidence as to the last known date at which the offence was still being committed, and she sentences in respect of those facts.
Just maybe thought rather strange that the magistrate would be required, or could potentially be required, to sentence in respect of a particular period without being aware of whether or not there is a continuing offence over a later period, which may support your submission. That it makes sense to have the whole thing dealt in one.
Well, yes, I say it is dealt in one, and I can't see circumstances in when it would be dealt with in more than one charge prior to the first determination by the court whether it's conviction or acquittal.
If you take your submissions to the logical conclusion, there's no need to amend the complaint.
Yes, this is exactly what I was going to raise. Yeah.
Well, in respect of the end date, no, there isn't.
Or the first date either, because the date's immaterial, and you just say, well, it's just bad luck. You can't sentence for that period.
Well, that's right. I mean, the magistrate applying the law, both parties would know that. So would the magistrate. Yes, that's right, my lord. So, may I move on to the Court of Appeal's judgment?
Yes, of course.
I'll try and take it quickly. I've got about 20 minutes left, I think. So, the Court of Appeal's reasoning is, I pick it up at paragraph 18, page 182. And the court, first of all, starts by looking at Hodgetts, and this appears to be where the court ends up going astray, as I say, and finding two offences, because it sees two offences in Hodgetts at 89.1 and 89.4, and sees the wording somewhat of those two provisions somewhat conflated in section 18.1, and so finds two offences in section 18.1 rather than one. So they go through Hodgetts, page 183 and 184, and then come to the appellant's submission, which is at paragraph 19. And the appellant submitted that there couldn't be a continuing offence without an initial offence, because there couldn't be an offence without conviction. So that was a kind of direct transposition of the effect of the English Act, which, of course, in this Trinidadian Act, there is no requirement of a conviction to create a continuing offence. Justice of Appeal Musai gives his reasons for finding a continuing offence, paragraph 20. I'll pick it up at the bottom of page 184, where he sets out what his understanding of Parliament's intention, and I would respectfully agree with and adopt that reasoning about the tendency to find that Parliament intended a continuing offence here. The problem comes at paragraph 21, where where Justice of Appeal Musai directly applies the decision in Hodgetts in respect of section 89.1 of the English Act to section 18.1 of the Trini Act. And of course, the Trinidadian Act is markedly different from section 89.1 in that it goes on to say, and in case of a continuing offence, and imposes a daily penalty, just as section 89.4 did in the UK Act. But you'll see that the Justice of Appeal Musai directly applies Hodgetts to find that the first part of section 18.1 is a once and for all offence. And that's the part that I respectfully disagree with. And on that point, I agree with the respondents that there is one offence under section 18.1, not two. And then, having found there were two offences, Justice of Appeal Musai goes on to find that the first offence is time-barred, the once and for all offence, that's paragraph 26. And in respect of the continuing offence, it's not time-barred, and that's the reasoning at paragraphs 27 and 28. And I respectfully agree with the reasoning at paragraph 27. And as for 28 and the period under consideration, well, as I've submitted, the proper period for under consideration, I say, begins on the 9th of April 2008. And so I say that the sentence, assuming that the daily fine remains unchanged, $200 a day, would be calculated at that rate from the 9th of April 2008. And as I had indicated earlier, I take the position that the first date, that is 9th of April 2008, is chargeable at the continuing rate, that is the maximum of $300, not the one-off rate, the maximum of $1,500, or as the...
So what's the overall fine? What should the overall fine have been?
I haven't actually calculated it, my lord, but I can do so. Would you be happy for me to send that in by email?
The question arises, I suppose, that if this is the correct approach to the situation, whether the question of sentencing can be dealt with in such a mechanical way, or whether it's necessary for it to be remitted in any event for the very different circumstances to be taken into account.
Well, it was dealt with in a mechanical way. The magistrate looked at the overall offence, looked at all the circumstances, and decided that $200 per day was the right sentence for this offence, given the nature of the offence and what she had been told, the little that she'd been told about the appellants, and then she calculated it mechanically. And when the Court of Appeal were asked to consider whether that was disproportionate, they said no, it's not a disproportionate amount.
They might have come to a different conclusion if they appreciated they were concerned with a different period.
Well, I find that hard to think that plausible, my lord, given that they had already decided that the larger sum was not disproportionate to the offence.
But clearly they should have exercised a discretion about imposing imprisonment and default.
Yes, and I say they did.
And what were the reasons for that?
Well, let's take a look at what they say, my lord. What they say is, okay. I'll get there. I'm just going to find my reference because at a different point of the.
Well, for instance, did they take into consideration whether or not they could have enforced the fine without sending somebody to prison?
Well, what they decided, my lord, was as follows. And it's with reference to the provisions in the Summary Courts Act. Here we are. Yes, paragraph 75, page 204. Now, I accept that when you look at the magistrate's reasons, she does appear to say, I have to do what's required by law, and I'm imposing a sentence of imprisonment in default.
But if paragraph 75 doesn't refer to any discretionary element at all, and if you could actually obtain the fine without sending somebody to prison, isn't that an appropriate thing to take into account?
Well, my lord, I say it does refer to a discretionary element because it refers to the words of section 68. And so we take a look at section 68. Now, in my submission, there's no reason to infer the Court of Appeal, having correctly referred itself to this section, that it misunderstood the effect of the section. That's the first thing I say. And that section 68 is at page 437. Section 68.1, as my learned friend has rightly pointed out, says that the court may impose a sentence of imprisonment in default. And then section 68.2 goes on to say the period of imprisonment shall be such period as, in the opinion of the court, will satisfy the justice of the case, but shall not exceed the maximum. So there's maximums, there's no minimum. The period shall be such as, in the opinion of the court, will satisfy the justice of the case. And that is exactly the exercise that the Court of Appeal set itself at paragraph 75. So, having looked at the magistrate's sentence, imprisonment with hard labour, Justice of Appeal Musai says that was unwarranted and disproportionate. But he goes on to say what, in his view, satisfies the justice of the case. Satisfying the justice of the case doesn't require the imposition of hard labour. The orders of the magistrate are therefore varied to prescribe terms of simple imprisonment in default of payment. So I say Justice of Appeal Musai is deciding that simple imprisonment satisfies the justice of the case, and that's exercising his discretion.
Still don't know on what basis.
Well,
because the sentencing people to prison can have a disproportionate effect, can have different effects in relation to different people. And I know the point you make is that not a lot was put before the Court of Appeal in relation to that. But some consideration as to why you're sending somebody to prison might have been useful.
Yes, my lord. I do make the point that not a lot was put before either court, and nothing was put before either court. As far as the magistrate was concerned, she asked for general mitigation and didn't receive any. When it got to the Court of Appeal, the submission was limited to one paragraph. The sentences are disproportionate and excessive.
As far as I'm concerned, a court should, before sending somebody to prison, actually make some inquiries about the relevant factors. Anyway.
Yes, my lord. Well, As far as...
no equivalent of social inquiry reports or means reports even in practice.
No, there is a provision about what about the means of the offender. That's section 70 of the Summary Courts Act. It says that the means shall be taken into account so far as they appear or are known to the court. But the magistrate asked questions of the appellants what they wanted to say about sentence. No such information was given to her.
Well, they know there's a property.
Yes, and they know that it's a 21-bedroom bedsitter, so it's probably earning a lot of money too.
But did they know whether it was charged?
No.
You look it up on the internet?
Well, I don't think the magistrate could.
It wouldn't be permitted to do so. I was just wondering whether the prosecution could have done so.
Well, in my submission, that's a matter for the appellants. The prosecution is bound to put before the court what it knows, but it's not bound to know.
No, I was just thinking in terms of, here you have an outstanding fine, there's a valuable piece of property which you could get your hands on, it may be generating an income, there may be bank accounts and so on. And, and before sending somebody to prison, aged, how old are they?
There wasn't any evidence before the magistrate how old.
And how old are they?
I don't know.
Well, we're told they're 75 and 71.
Yes, we're told we're told in the appellant's case. Yes, there was no evidence before the courts below. Shall I use my last 5 minutes just to deal with the question of reasons?
I'm still not clear what we should be doing. If we're with you,
My Lord, my submissions are that the board should dismiss the appeal against conviction, allow the appeal in part against sentence, and impose a sentence calculated at $200 per day, which the Court of Appeal thought was at the low point of the starting, low end of the range for the starting point. Impose that sentence from the 9th of April 2008 until the 17th of March 2017, which was when the magistrate found the offending buildings were still in place. As for the long period of time between complaint and conviction, I say 2 points about that. My Lord Stevens said it's an unexplained period of time. The full history of what happened in the Magistrates Court would have been before the magistrate. So she knew the history. So did the Court of Appeal. The full history isn't before your lordships. But the full record of the magistrate's proceedings is put together and sent up to the Court of Appeal. They have it before them when they decide. The magistrate had it before her when she decided. So those fines were made with knowledge of the history of proceedings in the Magistrates Court. And I make the point, of course, that at any stage it was open to the appellants to put an end to their offence. While we're on the point about the magistrate's record, there was a question over whether the magistrate convicted of one offence or two. I say if there's any ambiguity in the magistrate's oral decisions, that ambiguity is resolved by the minute of her decision at page 74. And I say there isn't any doubt about that, what that is. That is the minute of the magistrate's decision. It forms part of the Magistrates Court record, which was sent by the Magistrates Court to the Court of Appeal. That's why it's here in your lordship's bundle. There's no doubt about what that is. and it's plain from that at page 74 that one offence was, the magistrate convicted in respect of one offence. And as my Lord Reed pointed out, the appellants were charged with only one offence. I think I've got up until 3:35, so
You're not obliged to use it.
I'm just thinking about whether I can usefully say anything about the magistrate's failure to provide written reasons, other than refer your lordships to the judgment of the board in Cedeno and Logan, pages 890 and 88 to 891, and the statements of principle since then adopted in Trinidad and Tobago by the Court of Appeal. They've adopted a principled and consistent approach to magistrates' lack of reasons, and that's in the Jones case, 754 to 761. The statement of principle is at 761, paragraphs 38 to 39, and then that's refined in Montano at paragraph 86, which is at 668. And I submit what the Court of Appeal says there is good law. It's supported by the Canadian Supreme Court case of Shepherd, which they refer to there and which I've referred to in my case. And the Court of Appeal applied that good law in this case and was entitled to find that this was a decision of law on facts which were largely undisputed and straightforward. And if your lordships want to see where the best oral statement of the magistrate's reasons, that's at page 67, where she did actually give a reasonably clear oral statement of her reasons for finding the appellants guilty of the offence and for her decision on whether the complaint was brought in time. It's at the bottom of page 67. So this is the last thing I'll take your lordships to before I stop. So she's addressing the appellants in respect of sentence, but she's taking them through, actually, her findings on the offence. So she refers to the enforcement notice, and line 29, the steps in your case required by the notice were to demolish and remove from the land the structural additions specified. And then line 35, so those were steps you had to take. And line 37, and you've not taken the steps. So there's the reasons for the conviction right there. And as for the decision that the complaint wasn't brought in time, that's line 44 to 50. As long as you've not demolished and removed the additions, that's my interpretation. As long as you've not done so, then you remain in breach of that section and therefore liable. So she does give reasonably clear oral reasons for her decision. But as for the lack of written reasons, that's covered by the authorities I've referred your lordships to. So unless I can help your lordships any further.
No, thank you very much, Mr. Strange. Harry Lowe.
May I just deal with that last point? Can I invite the board's attention to page 70 of the record, which is another part of the magistrate's reasons that the board may wish to consider insofar as we have been able to identify why she passed the sentence she did. It's at lines 1 and 2, where she simply approached it mathematically. Mere fluctuation of time multiplies the penalty. And so having fixed the amount, she then just said, right, what's the total number of days? And then that was worked out as 8,000 odd days or something along those lines. We say that that type of mechanistic approach is not the correct approach, even when one is fixing a fine for a planning offence. But in any event, if the board were with the respondent in upholding the conviction, we would say that in relation to sentence, the variation that should take place should at least include the reduction considered by ex parte Franks, which is taking the 6 months prior to the laying of the complaint, a removal, or quashing of the sentence of imprisonment in default. And I simply mention this. I know it may have featured in another appeal the board heard somewhat recently, but although conditions of custody may not be relevant for bail, it's certainly relevant when it comes to passing sentence. And so if the court is going to impose a prison sentence, as this court did, bearing in mind the age of the appellants, that should have been a factor that weighed heavily against it. And I don't accept, and I would invite the board to reject, any suggestion the magistrate couldn't know how old they were. The magistrate was able to see these defendants over a period of time, as was the Court of Appeal. So it would have been clear that they were older, and certainly perhaps in their late 60s, if not 70s. So that is a factor a court can always take into account when considering the state of a defendant, previous good character and age. As far as the fine was concerned, yes, there was a property there, but I would highlight this, and we've highlighted it in our case. The original intention of the property was for multiple family occupancy. That was the evidence given at trial, that they were creating effectively a family home for all of various people. Now, whether or not that would have continued, that was, of course, 2002. That's a separate matter. But the original intention, insofar as the evidence supported that, was for some sort of family hub. I can't take it any further than that. We've touched on it in our case, and that is a factor that the board may wish to consider. As far as what the board should do if it is going to adjust sentence, well, we've indicated we say that the board should vary the sentence. If this matter is sent back, because of the delay that has already occurred, I'm not entirely sure how that would be resolved, and bearing in mind that the board has heard the submissions, particularly in relation to the principles of sentencing, the board probably has enough to make the reduction. And we would say that the final factor is one of delay. The board can take into account the fact that there has been a long delay. It was a factor that we submit the court should have been addressed on, certainly by the prosecutor. And could I invite the board, please, to look at the very last page of the bundle. This is at 1165, I think it is. And it's paragraph 15.6. The role of the prosecutor in the sentencing process, which deals with the legal limitations on sentence. The board has been addressed about that. That clearly wasn't taken into account. They're supposed to assist the court to avoid appealable error, but it's the next paragraph that is material. Draw attention to the court to any facts that may affect assessment of sentence. This applies equally whether it involves a mitigating or an aggravating factor. And if it were an aggravating factor, that delay should somehow be visited on these appellants, then the prosecutor would have said so and did not. So the board should not assume or proceed on the basis that there is some fault on the part of the appellants. And we say that because of what my learned friend has outlined, that if the magistrate was familiar with the record of the proceedings, if that were an aggravating factor, she'd have taken it into account expressly. But of course, this is the problem with no reasons. We are left to guess. And so we would say that there should be a reduction in the fine, the level of fine that has been imposed, and the board could make that adjustment. My Lord, can I now turn, please, to the case of Cayenne? My Lord, I invite a degree of caution in how the board approaches the case of Cayenne. This is at page 582. And the reason I urge caution is, of course, this was a Proceeds of Crime Act offence where the Court of Appeal was adding further guidance to the case of Payani, I think it was, that it had delivered some time before. And if the board looks at the top of page 582, the material consideration under Section 8 of POCA is subsection 2. The court must take into account conduct occurring up to the time it makes its decision. Take account of property obtained up to that time. And then if my lords turn to the page immediately before, you see why that's been set out expressly. And it's the middle of paragraph 15 on 581. Second, that Panay had been decided without reference to Section 8 of POCA or to the court's previous decision in Ali, each of which supported the prosecution's case that a defendant's POCA benefit from such an offence was calculable on a continuing basis. So we don't have any issue with that. That is something that the statutory regime under POCA permits. You can go further than any period that may have been specified in the indictment, as it were. Now, my Lord, I've already addressed the Board on ex parte Franks. Can I invite the Board's attention to the case of Tandridge District Council versus Powers? This is the the Respondent's extra authority, and invite the Board's attention to the law report. If you are on the electronic page number, it's page 8. If you are on the law report itself, it's 413 in the top right-hand corner. And my Lord, a lot of discussion, I mean, the Board has heard the competing arguments as to what Section 18, subsection 1 actually creates. But I make this observation. It does appear from the wording of Section 18, subsection 1, that although it can capture a first day and a continuing day, it does seem to have the nature of it of a one-off offence. Otherwise, after conviction, you'd be able to lay another one, and that doesn't appear to be the position. When you look at page 413, one of the interpretations that was attached to the then English statute 89 subsection 1, this is Chief Justice Widgery, it's about 8 lines down. Suffice it to say that in my judgment, when one reads section 89.1, that's the first part of the offence created, it has the smack of a single offence about it. And my Lord, we rely on that observation because it does seem, and we offer this for the Board's consideration, if you have to lay the charge within 6 months of the first day, and that is material as we've argued, then although it may cover more than one day, it would still be a one-off offence, albeit the nature of it is continuing, covering more than one day. Now, that's not a stretch of language. That is consistent with Section 18, subsection 1. So once the complaint is laid to capture day 1, then one can carry on within the period of complaint, and that would fit, we say, with laying the charge at the earliest possible time so that you don't end up with this very, very long period after you've laid your complaint before resolution. That's got to be consistent with Parliament's intention, not to be able to bring an offence, charge an offence which is resolved so late in the day. My Lord, we say that because otherwise you'd be able to lay the complaint, do nothing, and then come back some years after the event. And that can't be right. That doesn't fit with summary justice. And so we would invite the Board to consider that that is a way to resolve and apply the express wording of Section 18, subsection 1. As far as the Court of Appeal's consideration of this, we would also draw the Board's attention to page 204, and it is worth looking at because what we have been able to work out, and I think the Board will see, forgive me, if you look at the disposal on paragraph 76, this is what the Court of Appeal did. The appeal against conviction is allowed in part, having correctly inferred, we say, from the magistrate reasons she convicted of 2 offences, the order of the magistrate with regard to the conviction of the appellants for the initial offence is set aside. That's why we say that this is somewhat unrealistic to say, well, there's now one offence, we've got an acquittal here, which is not before the Board. But we say that it's very obvious why the Court of Appeal adopted that approach, because when you go back to see how the Court of Appeal dealt with the issue, and you've just looked at this, this is page 187 of the record, which is the Court of Appeal's judgment. It was pretty obvious from paragraphs 24 to 25 that the Court of Appeal correctly identified that the first day, because that was mentioned in Section 18.1, was material. That is almost certainly why they adopted the approach they did to say, okay, well, if I construe it as an initial offence and the continuing offence as a separate offence, then it works. We can quash the conviction for the initial offence because that's out of time, and we can convict of the continuing offence. So even the Court of Appeal, we say correctly on this, treated the first day as a material averment. And that has to inform what they decided, otherwise you wouldn't quash the initial offence at all. And if that is right, and we say that it plainly is, then the way in which we've sought to resolve how the offence is structured and how it should be prosecuted means you've got to lay your complaint within 6 months of the first day. And it is no answer to say, well, it's a continuing offence, therefore you can lay it at any time, because I've already outlined to the board each of the offences in all of the cases we've looked at, including those cited in Archbold and Blackstones, do not deal with the express wording we are concerned with here. And if Parliament uses words which has a particular meaning, then first day is a material averment for the purpose of locking and engaging the charge. My Lord, if you now look at, I think this is what, was it my Lord Hamblin's question about amending the charge? We would urge the board not to make any further amendments to the complaint. We say because there's already been one. If you look at page 188, paragraph 28, that's exactly what the Court of Appeal did. Because they construed Section 18 as creating two different offences, it's the second sentence. Failure to comply creates a continuing offence which may be the subject of prosecuting unless and until there comes to when there is compliance. I'm going to address that in a moment, but they then go on to say no risk of injustice in amending the complaint to capture just the continuing period. Now, they knew the first date was material. That's why they adopted this approach. Right in analysing it that it's material, wrong in trying to correct it in this way. But it doesn't just stop there, because when you look at the words, time comes when there is compliance, I do urge the board to take this into account. There seems to be some confusion between enforcement of removal of the building and commission of the summary offence. The summary offence is designed to criminalise and punish the failure to take down the building. It is not the same thing as enforcing the order to compel the owners to take down the building. That's Section 17, where the minister can take steps to ensure that. So we say that the respondent is wrong to conflate requiring the respondent, the appellants, to take down the building. That's not the purpose of the offence. The purpose is very clear from the Act, and the punishment is set out. That's all. Otherwise, you would find that the sentencing regime would have included an order, perhaps subject to a period of imprisonment in default, to take down the building. That's not the provision. So I just urge the board, please don't be persuaded that enforcement and compliance with the order is the same thing as punishing for the summary offence. We make that point, and we hope that that resonates. And we say that that is very clear, because when you look at the case of Hughes, this is 838. Sorry. Yeah, I'm grateful to Milena for Ms. McGibbon. I mean, the complaint can only be laid after the period of non-compliance has expired, and because of the wording of Section 18.1, that runs from the first day. That we say is very clear from Section 18.1. But if you look at how, when construing a criminal statute, we say the approach is very clear. If you look at page 838, this is the decision of Hughes from the Supreme Court. It's paragraphs 26 and 27. It talks about statute creating a penal provision, one very considerable severity, etc., and then goes on to quote Lord Hoffman at paragraph 27. And this, parliamentary sovereignty, means that Parliament can, if it chooses, legislate contrary to fundamental principles of justice. But the principle of legality means that the Parliament must squarely confront what it is doing and accept the political cost. Now, I'm not going to read the whole thing out, but essentially, my Lord, if you are going to create a summary offence, as this judgment makes clear, then it's got to be construed with a degree of strictness in favour of the accused. And we say that that is very clear from 839 at A, where those words are expressly used by the court. And so it is open to Parliament to create continuing offences if it wants to, and it is open to Parliament to create them to be laid at any time. But it is not open to Parliament to use loose language and then expect the courts to fill in the blanks. And we say that what the respondent has effectively done is to say that is so, that the court should give a construction to Section 18.1, despite the fact that the first day is expressly mentioned, and effectively ignore it. Well, 2 points in relation to that. The first deals with Lord Neuberger's comments. This is at 798. And I would invite the board to look at it. And this is the case of Williams versus Central Bank of Nigeria, where Lord Neuberger was concerned with the approach, the correct approach we submit, to be adopted in relation to construing statutes. And it's the middle of the paragraph 72 on 798. When interpreting a statute, the court's function is to determine the meaning of the words used in the statute. The fact that context and mischief are factors which must be taken into account does not mean that when performing its interpretive role, the court can take a freewheeling view of the intention of Parliament, looking at all admissible material and treating the wording of the statute as merely one item. Context and mischief do not represent a license to judges to ignore the plain meaning of the words that Parliament has used. And then it goes on to deal with Lord Reed's comments in Black Clawson International. It is often to say we're looking for the intention of Parliament, but that's not quite accurate. We are seeking the meaning of the words which Parliament used. So the respondent's submissions about what Parliament intended, that's all well and good, but those are not the words that they used. And we would invite the board to consider that. And in considering it, there is this point. The cases you've been taken to about events, conviction and so on, and then another offence following after, continuing offence, that's fine for the cases in which that decided it. But we're not here talking about an event before the continuing offence can be laid. We're talking here about a date. They are two different things. The statute does not look to an event as such. It looks to the first day of non-compliance. So where, for example, if it had said conviction, it wouldn't matter when the conviction had occurred, because once the event of conviction has taken place, time doesn't really matter. That's the material averment for that purpose. Lord.
Do you accept the general proposition put forward in Blackstone's that the date of the offence isn't necessarily material? And if there's a divergence between account and the evidence as to date, it's not itself fatal to a conviction. It may be unnecessary to the prosecution to apply to amend, but as a matter of good practice, they frequently do.
My Lord, I can answer you directly. The general principle is that dates are not a material averment, and that is normally the case, unless, of course, the statute makes it such. Then in which case it does become one, which is why we relied on Maltedge and the wording of Section 18, subsection 1.
Yeah. Okay.
In relation to the words "and not after," my learned friend has taken you to various cases, but I maintain the case of Cook and Cook doesn't deal with that. It's not what the case turned on, and they don't give any interpretation. So the worst possible interpretation should not be given. And as far as their reliance on the cases of Skinner, Mary Owen, and Shaw versus Singer Sewing Machine, well, I've made the point already. They don't actually concern Section 33(2). The courts in that case were not concerned with a summary offence, so no assistance can be gained from a consideration of a section applied to a procedure that doesn't actually, that is irrelevant. So we simply rely on that. As far as the reference to the BWI case at 144, which my learned friend took the board to, and I'm just coming to finish, again, the mere extract is not of assistance. It's a different worded offence and cannot assist in this case. Could I just pause for a moment, my Lord? I know I'm almost at the end. My Lord, finally this. If the respondent's reasoning is correct in upholding the conviction, it would mean that you'd never be able to capture the first day of the offence for the purposes of the fine created by Section 18.1, because you could lay the offence long after the 6-month period that would capture it. Can I assist the board further?
I don't think so. Thank you very much, Mr. Baharilal. We're grateful to all counsel for their assistance and to those sitting behind them. We'll now take time to consider our judgment. Court will adjourn.